मंत्री श्री अमित शाह जी की ओर से प्रस्ताव करता हूं कि आपराधिक मामलों में पहचान और जांच के प्रयोजनों के लिए दोष सिद्ध व्यक्तियों तथा दूसरों की माप को प्राधिकृत करने तथा अभिलेखों के परीक्षण तथा उससे संसक्त और उसके आनुषंगिक विषयों को उपबंध करने वाले विधेयक को प्रस्थापित करने की अनुमति दी जाए।
श्री मनीष तिवारी जी।
Thank you very much, Mr. Speaker, sir. I rise to oppose the bill as it is in derogation of both Article 20, Sub-Article 3 and Article 21 of the Constitution of India and therefore beyond the legislative competence of this House. Mr. Speaker, sir, Article 20, Sub-Article 3 explicitly states, no person accused of any offence shall be compelled to be a witness against himself. The words biological samples and their analysis in clause 2(1)(b) of the bill could extend to narco-analysis and brain mapping, and when it is made coercive in terms of clause 5, it is clearly violative of Article 20, Sub-Article 3 of the Constitution of India. Further, Mr. Speaker, sir, the implied use of force in clause 6(1) to take measurements violates the rights of prisoners laid down in a catena of Supreme Court judgments, beginning with A.K. Gopalan 1950, Khadak Singh 1964, Charles Sobraj 1978, Sheila Bharse 1983, Pramod Kumar Saxena 2008. Mr. Speaker, sir, just 2 minutes. Section 4(2) of the bill states that record of measurement shall be retained for 75 years from the date of collection. This is in violation of the right to be forgotten, enshrined in the right to life under Article 21 of the Constitution in terms of the Puttaswamy judgment. Mr. Speaker, sir, I will just conclude by saying, this August Assembly must very seriously deliberate that whether it is in the legislative competence of the Treasury to sponsor legislation which squarely hits the fundamental rights guaranteed to the citizens of India under Part 3 of the Constitution, and whether it is within the legislative competence of this August House to consider such illegal legislation. That is my objection to the bill.
N.K. Premchandan ji.
Sir, I fully support. Sir, I fully support the observations of Honorable Member Sri Manish Tiwari ji. And I rise to oppose strongly because this is a draconian legislation on the part of the government. Why I will say? So the rights of fundamental rights in Part 3 of the Constitution is being totally violated. Sir, Clause 3, Subclause C of the bill says that if a person who is arrested in connection with an offence punishable under any law for the time being in force, his biological specimens can be taken for investigation. Sir, if I am arrested, you kindly go through the bill. If I am arrested in picketing the collectorate for the civil right protection or for any genuine demand, if I am arrested and FIR has been lodged against me, suppose if a DNA test can be taken from me. What is this? This is the basic human right of a particular individual. It is being taken away. What is the reason? What is the logic, intention of the bill? Kindly explain this bill. That is why I am saying that this is directly violation of the fundamental right. Not only the convicts, sir. Honorable Speaker, sir, the A says regarding the convict. Convict for which offence? Suppose a penal offence, suppose 100 rupees penalty. Sir, very important, sir. Suppose 100 rupees penal fine is imposed. He is a convict. From him, DNA biological specimen can be taken. All these biological specimen can be taken means, then what is the fundamental rights? So it is violation of Part 3 of the Constitution, number 1, and it is against, sir, it is against the UN Human Rights Declaration. That is also very specific human rights violation. So since it is human rights violation and fundamental rights violation, there is no legislative competence of this House to pass such a legislation. Definitely this will be struck down by the Supreme Court or the High Court. So I urge upon the Honorable Minister, please, Honorable Speaker, please don't allow the government to introduce a bill since it is violative of the Constitution, ultra vires the Constitution.
माननीय सदस्यगण, जब कोई एक माननीय सदस्य ने एक विषय पे विरोध कर दिया और अपना पूरा वक्तव्य दे दिया है, ऐसे तो इस सारे विषयों में नियम 72 के अंदर विधायन क्षमता से परे हो तब इस पर डिबेट पर चर्चा की जाती है। लेकिन जब पूरी डिटेल चर्चा होगी, मैं आपको पर्याप्त समय पर्याप्त अवसर दूंगा। आप अपने विषय वस्तु पर उस समय रखना। अभी आप ये बिल लाया जा सकता है नहीं लाया जा सकता, विधायन क्षमता संसद की है या नहीं, सरकार की नहीं, इस पर विचार करने की आवश्यकता है। सौगत राय जी, कानून से बोलेंगे आप।
धन्यवाद अध्यक्ष जी,
बहुत दिनों
बहुत दिन बाद बोलने का मौका मिला।
आप बाहर थे।
And under Rule 72(1), I oppose the introduction of the Criminal Procedure Identification Bill 2022. I do not want to repeat the arguments already forwarded by learned Manish Tiwari and N.K. Premchandan. But sir, you will know from common sense that it is the basic principle of law that nobody is found guilty unless proved in a court of law. The second right people have, that if somebody is arrested, he has to be produced in court within 24 hours, and he has a right to be represented by a lawyer. Now, so far, from 1920, the original bill was there. It has been going on. Suddenly it comes to the brain of the Home Minister that we must make it stricter. We must take fingerprints, the iris photographs. Why? And biological samples. Why? This and narco-analysis, brain mapping. सर, अचानक क्या जरूरत पड़ गया कि अचानक क्राइम क्या बढ़ गया है? ये सरासर हमारा, sir, you know, from 20 to 24, all the articles in the Constitution deal with the human rights of people. This law, which allows for narco-analysis, which allows for taking biological specimen, taking the photograph of the iris, this violates basic human rights and is against the principle of the Constitution. सर, आपने अभी बोला है कि बाद में बिल के चर्चा के समय उठाइए, लेकिन एक गलत बिल आपको सामने लाया जाए इंट्रोडक्शन के नाम में, ये सरासर हाउस का खिलाफ होगा, हाउस का नुकसान होगा। इसलिए मैं आपसे अर्ज करता हूं, सर, इसको इंट्रोडक्शन मत होने दीजिए। होम मिनिस्टर आए, एक्सप्लेन करिए। टेनी जी क्या समझाएंगे सर? ये होम मिनिस्टर को समझाने का जरूरत है। धन्यवाद सर।
श्री अधीर रंजन चौधरी जी।
Sir, I rise to oppose vehemently under Rule 72(1), introduction of the Criminal Procedure Identification Bill 2022. Sir, the reason being, the law can ask those people who have been convicted by the court to give their biometric measurements. However, the present bill, I would reiterate, however, the present bill seeks to empower the police and court to take measurements of persons who are under trial or who are suspected to be involved in a case, or there is a presumption against some person that he may in the future do any illegal act. These provisions are violative of Article 21 of the Constitution, that is right to freedom and personal liberty. So the provision of the bill also violates the judgment given by the Supreme Court in Puttuswamy case. That means the provisions are against the right to privacy. Right to privacy as propounded in the Puttuswamy case, that is also being violated by this kind of draconian law. Sir, given that the cases of custodial violence are high in India, there is a high possibility of forceful measurement resulting in lifelong stigmatization and grave violation of human rights. Sir, in absence of any form of data protection statute, the bill might do more harm than good. Additionally, in such a highly unregulated area, there is little empirical data supporting the accuracy of criminal profiling, in addition to the absence of criteria for what constitutes an expert in the discipline. So, all the छोटे-छोटे point है sir. Lack of technology and margin of grave error. Currently, sir, हो गया. Currently, India does not have any advanced technological equipment to profile offender. Even in far more technologically advanced countries, there has always been a margin of error in such profiling. There have been several cases where these errors have resulted in incarceration of innocent citizens. सर किस लिए ये वायलेट कर रहे हैं ये मैं बयान देता हूं. सर क्लॉज 7 सर हो गया. सर क्लॉज 7 of the bill exempt any person or authority from any resulting liability. It states that no action or other proceeding shall lie against any person for anything done or intended to be done in good faith under the act or any rule issued thereunder. So it is clearly vindicating our argument that this bill is not in accordance with our constitutional provision, and it is certainly a bill which is a direct affront to our constitutional provision. Thank you, sir.
धन्यवाद अध्यक्ष जी.
देश पांडे.
मैं क्रिमिनल प्रोसीजर आइडेंटिफिकेशन बिल के विरोध में यहाँ पे उठा हुआ हूँ, इसके इंट्रोडक्शन के विरोध में. अध्यक्ष जी, संविधान में आर्टिकल 21 के तहत जो मूल अधिकार हमारे देश के नागरिकों को गारंटी दिए गए हैं उनका हनन हो रहा है. वो इस कारण से हनन हो रहा है क्योंकि जो हमारे आज जो भारत सरकार है वो ये चाहती है कि लोगों को एक भय में रखा जाए. उनके ऊपर अगर कोई भी यहाँ पे सदस्य किसी भी चीज को लेकर के कलेक्ट्रेट के सामने अगर कोई विरोध रखता है तो उसको ऊपर अगर कोई केस होता है तो उसको लेकर के भी उनके मेजरमेंट्स यानी कि उनके फिंगरप्रिंट, आइरिस, डीएनए सैंपल्स वगैरह तक रखे जा सकते हैं. ये पूरी तरह से एक मानसिक रूप से नागरिकों के ऊपर दबाव बनाया जा रहा है ताकि वो कभी भी किसी भी जो है अपने अधिकारों के लिए सामने लड़ने में आने में हिचके. इसलिए ये आर्टिकल 21 का हनन हो रहा है. सर मैं
माननीय सदस्यगण 72 रूल